Okay, well, it's 2 minutes past the hour, Lisa, so I think we'll make a start. And first of all, can I just say welcome to everybody who's joined us. It's a remarkable time we're living in, and we're on the cusp of something now as we move into the next phase in our relationship with the virus. But this has been a busy year for many of us, and the Supreme Court has been busy because it's tackled two rather meaty subjects which have been really in development for some 25 years, certainly through most of my career. This has been one of these two areas have been important. And the reason they're important is because the two subjects we're discussing today are subjects that are really for creative lawyers. If I can just share my screen with you, and give me a moment whilst I do that. There we go. So I'm going to give a very short introduction to the subjects that are going to then be discussed in more detail by my colleagues Naomi and Seb Oram. And so really what I'm intending to do now is simply set the scene initially for Naomi to discuss vicarious liability, and then I'll come back and do a short introduction in relation to the near reflective loss principle. As I say, these two areas are both important because they are often used by creative lawyers who are seeking to find remedies where there would be no other redress. And I think that's one of the common links between these two principles that are under examination today. So what about vicarious liability? The Court of Appeal has dealt with this on several occasions, as has done the Supreme Court, but the Supreme Court this year, in Barclays Bank and various claimants, and in W.M. Morrison's and various claimants, revisited this area. And since this was considered to be a developing jurisprudence and a moving feast, it's helpful, I think, to devote some time today to this area. I'm going to look very, very briefly now, because I'm eating into Naomi's time, into the law as it stood before these judgments, at least how it was understood, I think, by most practitioners, and just to introduce you to the subject. So what is vicarious liability? It's when the putative defendant is liable for the actions of or the omissions of a tortfeasor who's done the wrong, and even though the putative defendant is not himself directly responsible, he becomes liable through the principle of vicarious liability. It's important to remember that the actual tortfeasor always remains potentially liable. And if he had the means to do so, then he might be called upon to indemnify the putative defendant. So where has this doctrine come from? Well, it's not entirely clear. It's certainly grown through the common law. And as Lord Pearce said in a case called Imperial Chemicals and Shadwell, the doctrine has not grown from any very clear logical or legal principle. That's a good start, isn't it, for any webinar discussion. Having said that there is no principle, there is a way of breaking it down into these components by asking the three questions. First of all, there has to be some actionable wrong, a wrong committed by the real tortfeasor, whether that's a breach of a common law duty, tort as we understand it, whether it's a breach of an equitable duty, or whether it's a breach of a statutory obligation. All of those give rise to the first primary question of whether there's been a wrong. Secondly, we need to consider what's the relationship between the person who is responsible for the acts and omissions, who's committed the wrong, and the putative defendant. And the core relationship from which most of the case law associated with vicarious liability arose was a relationship of master-servant, borrowed servant, often therefore in the context of what we would call employment. But as we have seen, there's been a tendency to try to push the boundaries on that relationship to relationships which are analogous to employment. And in particular, one's concerned in the third question, in order to be able to pin vicarious liability onto the putative defendant, of what's the connection between the wrong that was committed by the actual tortfeasor and that tortfeasor's relationship with the putative defendant. And that used to be put very crudely on the question of what are the what's the scope of the employment, to what extent does this represent what is sometimes called the frolic of his own, using borrowing from agency, has it been done within the bounds of authority? And this third question itself is complex and isn't easily determined. So for that reason, it was said by Lord Phillips that the law was in motion. He said that, and it's quoted in the Supreme Court, that the law of vicarious liability is on the move. Lord Reed said in Cox that it hasn't stopped. We'll have to re-examine those statements in the light of what Naomi is going to tell us about the Supreme Court, and come back to that maybe if there's time for discussions. I'd probably taken more of my time than is sensible at this stage, but I think I've sufficiently set the scene to hand over to Naomi, who's going to take us through the Supreme Court decisions.
Thank you, David. I will now share my screen. So, as David explained, this area of law, which was once fairly straightforwardly defined as being in the classic master and servant relationship or employee and employer relationship, has in the last few years become somewhat more complicated. If nothing else, because the relationships that we have in work are in and of themselves more complicated. So the title here, Still Moving with a question mark, as David suggested, does reflect Lord Phillips' judgment, where he suggested that the law of vicarious liability back in 2012 was on the move. And what I want us to reflect on, but probably not answer fully over the next 20 minutes or so, is whether that is still the case. Now, I come to this area of law with a mixed civil practice, but a large part of my practice being employment law. And so I see this and look at this area through the lens of an employment lawyer. And one of the significant features, particularly in relation to the relationships between B and C, we'll call them, over the last few years, has been, in my view, a move away from employment law initially, and then to an extent a realignment between employment law and the common law and civil law in this area. And I'll demonstrate that looking at the cases. Two parts of the test I'm going to look at. David set out the three parts: the wrong that was done, the relationship between the wrongdoer and this other individual company, and finally whether or not the acts of the wrongdoer were within the realms of what they were being asked to do. And I'm looking at the last two parts, what we call first the relationship akin to employment, and secondly whether those actions have a sufficiently close connection to the employment or other relationship. So looking first at the relationship akin to employment question, David's taken you through some of the background. Rather than take you through case by case, what I've done here is divided some of the recent appellate authorities into those on the left of your screen, which are where a relationship akin to employment was established, and those are on the right of your screen where there wasn't, and drawing some themes out of the two of those, and looking in relation to finally the Barclays Bank decision, where we are now. The first two of those cases, it's interesting, in my view, to look at the background and to an extent the facts of these cases to distinguish as to why they may have fallen into one category or the other. Looking first at the first two, E, an English province of Our Lady charity, and various claimants in the Catholic Child Welfare Society, which is known as the Christian Brothers case. Those are both cases which involved Catholic priests who either allegedly or in fact did abuse children, and the relationship with them, and in the first case the local diocese trust, and in the second case an unincorporated association called the Institute of Brothers of Christian Schools. So of course there wasn't a employment relationship between the priest and these bodies, so the courts had to look at whether or not they could establish a sufficient enough relationship to say that these bodies were vicariously liable for the acts of the priests. In E, this was the first time it was clearly stated that a relationship for vicarious liability had moved beyond the contract of employment that was necessary from employment law. This was the decision of Lord Justice Ward in the Court of Appeal. And he said that if the case is one where an employee seeks a remedy against his employer, for example, for unfair dismissal, this does require a true relationship between employer and employee to be established. On the other hand, a remedy for an innocent party against an employer of the wrongdoer has a very different justification, rooted in public policy, as David has suggested. And therefore, the fluid concept of vicarious liability should not be confined within the concrete demands of a statutory construct, which had been developed and was arising for a very different set of reasons. So the test that came out of this was not whether or not there was a relationship of employment, but whether there was a relationship so close in character to one of employer and employee that it was just and fair to hold an employer, person will call an employer, vicariously liable. And again, this is going back to the idea that this area of law is rooted in justice and fairness and no clear conceptual narrative. Thus, at this point, the test became whether a relationship was akin to employment. We then have the Christian Brothers case, and in that case, the Supreme Court suggested there was a 5-part test for whether or not there was a relationship akin to employment. That test looked at things like the control that the, again, we'll say employer had over the employee, whether or not they put them in the position of having the risk of that, of committing the tort, whether or not they had the means to compensate victims, or victims of torts in these sorts of cases, and those kind of tests. So those are the first 2 decisions, both involving priests. We then look at 2 decisions on very different sets of facts. Cox and the Ministry of Justice, and Arms in Nottinghamshire County Council. Cox was a prisoner who worked in the prison kitchen under the supervision, the case of Cox was about a prisoner who worked in a prison kitchen under the supervision of a manager, Mrs. Cox. Mrs. Cox was injured by a prisoner who dropped a bag of rice onto her during a kitchen shift. And the question here was the prisoner wasn't an employee of the prison, but they were working in the prison as part of the rehabilitation programme. And the Supreme Court had very little difficulty in finding that there was a vicariously liable relationship akin to employment between the prison and the prisoner. Applying the tests set out in Christian Brothers, it focused mainly on the fact the prisoner was acting on behalf of the Ministry of Justice in doing the work in the kitchen. It was part of the Ministry of Justice business activities to be producing food for prisoners. And by taking the prisoner on as somebody to work in the kitchen, somebody who looked like an employee, they were creating the risk of the tort. So these are the sorts of factors that played in there. We then have Arms in Nottinghamshire County Council, and this was about whether or not a local authority could be vicariously liable for the acts of foster parents who abused a child in their care. Again, the Supreme Court looked at these tests and looked at the relationship between the local authority and the foster parents, said that the foster parents were carrying out an activity for the benefit of the local authority, that the local authority created the risk of the tort by placing the child in their care, that there was a level of control by the local authority over the foster parents, and that the local authority were far more likely to be able to pay compensation. So tying these cases together, we can see that none of these four cases are a typical employment relationship, a typical commercial relationship. They're all quite individual circumstances. They're not in the course of ordinary commercial business. This contrasts those cases on the other side of your screen, where a relationship akin to employment wasn't established. I first put the Supreme Court decision in Woodland and Essex County Council. This actually wasn't about vicarious liability, but in and of itself, that's important. In this case, a child suffered a tragic accident in a swimming pool under the supervision of a swimming instructor, and that swimming instructor had been subcontracted to by the local authority and acted as an independent contractor. The case was in fact about whether or not the local authority had a non-delegable duty of care towards children who had swimming lessons when it was a local authority's business to provide those. Non-delegable duties of care is a topic of a whole other webinar. But what's important is that the Supreme Court noted that vicarious liability wasn't applicable here because it has never extended to the negligence of those who are truly independent contractors, such as a swimming teacher in this case. And this idea of people being truly independent contractors becomes important in the following appellate decisions. We then have the case of Kafagi and JBW Group. This was a Court of Appeal decision sandwiched between Cox and Arms on the one hand and the Barclays Bank decision on the other. It was a case where the defendant was a judicial services company who subcontracted the collection of certain council tax debts to an independent, a bailiff who acted as an independent contractor and ran his own business. This bailiff attended the claimant's property, and it was alleged that there was some sort of altercation and a trespass to property and trespass to the person. The claimant sued the judicial services company rather than the bailiff himself. And so the question for the Court of Appeal is whether this company could be liable for the acts of the independent bailiff. The Court of Appeal reviewed three Supreme Court authorities I've just talked you through and said there was nothing in those that suggest that independent contractors people were liable, vicariously liable for the acts of independent contractors, and that relationship could not be regarded as akin to employment. Which takes me on to the final decision in Barclays Bank, the most recent decision. In this case, all the claimants had been employees of Barclays Bank, and upon starting their employment, they had to have a medical examination, and the conduct of those examinations was subcontracted to a Dr. Bates. He was a GP, and he had what's described in the judgment as a portfolio practice. This meant that he was an employee for certain hospitals and did his duties as a GP there. But he also ran his own business, conducting medical examinations, for example, for employers. It was alleged during these examinations that he committed a number of sexual assaults, and the claims were brought after his death and after his estate had been distributed. So, like David suggested at the beginning, this case was all about remedy. It was about people trying to get a remedy when they couldn't get one from the alleged tortfeasor himself. In this decision, in the litigation, the two sides of the argument were, on the one hand, by Barclays Bank, that independent contractors, such as Dr. Bates, had never been vicariously liable and couldn't be on the case law. On the other hand, for the claimants, they suggested that the recent case law wasn't quite as clear-cut, and applying the broader five-part test in the Christian Brothers case suggested that the law had moved on from that, and that a relationship akin to employment could be found here. So this forced the Supreme Court to reconcile these two streams of case law, as it were, which divide the screen, and they had very little difficulty in doing so. Lady Hale said, a bit like the Court of Appeal in Kafagi, that there was nothing in what she called the trilogy of Supreme Court cases to suggest that the classic distinction between relationships akin to relationships of employment or akin to employment or analogous to employment on the one hand, and those of independent contractors on the other hand had been eroded. So she suggested the case law was still very distinct, and she cited Kafagi and also a decision of the Singapore Court of Appeal to make clear that that was still the case. She went on to then clarify the position around the test in the Christian Brothers case. She said that the question, therefore, is and always has been whether the tortfeasor is carrying out a business on his own account, or whether he's in a relationship akin to employment with the defendant. In doubtful cases, the test identified by Lord Phillips may be helpful in identifying a relationship which is sufficiently analogous to employment to make it fair, just, and reasonable to impose vicarious liability. Although, and to go on, it's not on your screen, although they were enunciated in the context of non-commercial enterprises, they may be relevant in deciding whether workers who may be technically self-employed or agency workers are effectively part and parcel of the employer's business. But the key, as it was in the 3 Supreme Court cases, will usually lie in understanding the details of the relationship. Where it is clear that the tortfeasor is carrying out his own independent business, it is not necessary to consider those 5 incidents in that 5-part test. And in doing this, Lady Hale suggests at the end of her judgment some guiding principles to help practitioners and employers and people in these situations to establish when a relationship might be akin to employment and when it might not, and when it might be an independent contractor. And this is where I suggest she, to an extent, brings the law of vicarious liability somewhat in line with that of employment law. She says that it will be tempting. So in employment law, there are 2 types of work that we have: traditional employees. We have those known as Lim B workers, which comes from section 230 of the Employment Rights Act, subsection 3, subsection B. Those are people who work under what's called a contract to perform services, not as a traditional employee in a full employment relationship, but something that does look a lot like employment. Some recent examples you may have heard of, and if there are employment lawyers on the line, they'll know exactly what I'm talking about. There was a Supreme Court case of Pimlico plumbers, people that worked as plumbers under the umbrella of an organisation called Pimlico Plumbers. They were found to be workers for Pimlico Plumbers, even though to some extent they looked like self-employed independent contractors. Also, a big hot topic in the employment law world is Uber drivers, and the Court of Appeal have found those to be workers, workers for Uber, although that is currently subject to a Supreme Court appeal, which has been heard and judgment hasn't been handed down. And what Lady Hale suggests is that it's tempting to say that Lim B workers encapsulate the distinction between those whose relationship is akin to employment and those who are truly independent contractors, and that asking that question may be helpful in identifying true independent contractors. So it's on that basis that I suggest that the law of vicarious liability has somewhat realigned itself with employment law, and it may be useful to turn to employment lawyers to ask the question, is there a relationship akin to employment here? However, Lady Hale doesn't go quite as far as to suggest that these are perfectly aligned, saying it would be going too far down the road to tidiness for this court to align the common law concept of vicarious liability developed for one set of reasons which we've looked at, with a statutory concept of worker developed for quite a different set of reasons. And actually, looking back at the examples, foster carers are one example of this. They've been found not to be workers, but of course they have been found to be in a relationship akin to employment. So it's not a perfect test, but I think it does allow some clarity in this area of law, which I think, given the amount of appellate authorities over the last few years, is needed. And as I said, it may be time to to turn to employment lawyers to ask this question, at least to guide practitioners on where to go in this area. So that's the first part of the test. I'm very briefly going to deal with the second part and the recent Morrison's decision. In this part of the test, the key question is whether or not there's a sufficiently close connection between the acts that the, we'll call them employee for now, employee have done, and the thing that they're employed to do. I first highlighted one case back from 2002. This isn't a complete set of all the authorities in this area, but simply some of the recent highest level decisions. In Dubai Aluminium and Salam, this was an issue about a partner in a solicitor's firm who had assisted with acts of commercial fraud, and whether or not that the firm could be vicariously liable for the solicitor's acts. The House of Lords held in that case and really established a test in this area, that the wrongful conduct must be so closely connected with the acts the partner or employee were authorised to do for the purpose of the liability of the firm or the employer to third parties, that the wrongful conduct may fairly and properly be regarded as done by the partner while acting in the ordinary course of the firm's business or the employee's employment. Again, it comes back down to ideas of fairly and justly regarded as in this area of law. This has been recently tested, this idea, in 2 Supreme Court decisions involving Morrison's. Again, I'll only touch on them briefly, but in the first, an employee of Morrison's at a petrol station kiosk had an argument with a customer who attended that petrol station, which included threatening and racist language. He followed the customer back to his car. He opened the car door. He continued to threaten this customer. He told him to get off the premises, and then he assaulted him. There was an altercation. The Supreme Court held that these actions were sufficiently closely connected to his employment, and that when the argument broke out in the petrol kiosk, the employee was acting within the field of his activities, and then said that there was an unbroken sequence of events between that point and the point of assaulting this customer, which they also described as a seamless episode. And so they said that there was a sufficient connection with his employment. They also noted that in this case, the employee's motive was irrelevant. So the reason why he was doing it wasn't relevant to the fact that it was within the field of his employment or closely connected to his employment. Now, these words of unbroken sequence of events and seamless episode caused quite a lot of excitement in the legal community about how close in time or causal connection the acts of an employee had to be closely connected to their employment. And this was ironed out in the more recent Morrison's decision, the Morrison's Supermarkets and Various Claimants. Very different set of circumstances here. Here an employee, Mr. Skelton, was an auditor and had been auditor for Morrison's. He'd been the subject of an internal disciplinary process for a minor disciplinary matter and had a verbal warning. But it appears that from that point on, he bore a grudge against Morrison's and wanted to do something to get back at them. He was, as part of his work, he was provided with payroll data to audit, and he illegally copied this payroll data for all of Morrison's employees, uploaded it onto a publicly accessible site. He also sent this data to 3 newspapers who at this point alerted Morrison's, and Mr. Skelton was caught. Many employees of Morrison's brought group litigation with claims under the Data Protection Act, misuse of private information and breach of confidence. And the question was whether or not Morrison's could be vicariously liable for the acts of Mr. Skelton. Now, the High Court and Court of Appeal looked at the previous Mohammed and Morrison's decision and applied the unbroken sequence of events idea and suggested that because Morrison's in effect put him in the position by providing him with the data, and there was an unbroken sequence of events between that point and uploading it to this website, that there was a sufficient connection. But the Supreme Court overturned this, and in doing so reviewed the understanding that I think a lot of lawyers and the judges in the courts below had of the Mohammed and Morrison's decision. They made clear in that case that the previous Supreme Court decision had not departed from the Dubai aluminium test, and that the reference to an unbroken sequence of events or a seamless episode wasn't directed to any sort of temporal or causal connection between the events that happened, but actually it was to do with the capacity which the employee in the petrol kiosk was doing those acts. So for example, the fact that this petrol kiosk attendant ordered the customer off the premises was, even if very misguidedly, done in his capacity as a petrol kiosk attendant, not done in any independent capacity. And where the Supreme Court had said his motive was irrelevant, the point there was that they weren't really clear what his motive was for doing all of this. So it didn't play into whether or not those acts were sufficiently closely connected to his employment. The Supreme Court in the later Morrison's decision reaffirmed the test in Dubai Aluminium that the wrongful conduct must be so closely connected to the acts the employee was authorised to do that it may fairly and properly be regarded as being done in the course of the employer's business. That's the test I took you to before. But looking at that in the second case, the disclosure of data on the internet was not part of the employee's, Mr. Skelton's, field of activities in any way, shape or form. It was not an act he was authorised to do. And the fact that there was that temporal connection and causal connection between being supplied with the data and posting on the internet wasn't enough to satisfy the close connection or sufficiently close connection test. In this case, unlike the first Morrison's decision, his motive wasn't irrelevant. He was acting for purely personal purposes because he wanted to get back at his employer for what he felt they'd done to him. And so in this case, motive was relevant, unlike in the previous case where motive wasn't. And in doing so here, the Supreme Court reaffirmed another line from the decision in Dubai Aluminium, that there's a distinction to be drawn between cases where the employee was engaged misguidedly, even if misguidedly, in furthering their employer's business on the one hand, and cases where employees act solely in pursuing their own interests on the other. And this has been known as being on a frolic of his own, something that David mentioned at the beginning. And so it found that in Mr. Skelton's acts, Morrison's were not vicariously liable for the publishing of that data. So in some ways, this final case is interesting because of how uninteresting it is. All the Supreme Court have done is reaffirmed the sufficiently close connection test in Dubai Aluminium, and made very clear that some of the comments made in the Mohammed and Morrison's decision about unbroken sequence of events and seamless episodes were only really relevant to that case, and that the law is as it stood back in 2002. So the question you really have to ask yourself now is whether conduct will be properly regarded as connected to employment on the one hand, or whether an employee has been acting on a frolic of his own and for their own personal purposes on the other. And that's the test we've got to go with, and that's what the Supreme Court will apply. So that's a very speedy run through of the recent decisions. I'm now going to hand over to, I think I'm handing back over to David to introduce reflective loss and then hear from Seb. Thank you.
Yes, thank you very much indeed, Naomi, and thank you for that. And just for the people who are, we've got a very large number of participants online, and we're very glad to have you all here. Can I just mention that we are planning to complete the talks by 12, but we're going to extend our time because there's been some very interesting questions we've been receiving on the live chat, and therefore I'm going to extend the time till 12:15 to allow us to cover as many of the questions as possible. But do bear with me, And I do hope to reach as many of the questions as possible, so keep them coming as I move now on to the next of our subjects concerning the no reflective loss principle. And I'm now going to share my screen for that purpose. So, very good. So this is another very significant area that has been looked at. Let me just go to my yes. Forgive me. So Seb Oram is going to be taking us through Sevilla and Marex, when the Supreme Court looked again at this question, which has been around for some time and is a complex one concerning the limits and application of the no reflective loss principle. What is the principle? The principle is that where a wrong has been done, and that wrong has been done, say, to a company, and also it's been done to another victim, the question arises as to the extent to which the victim, other than the company, is able to recover losses. And that has been expressed in the following way. So the first point of the principle is that we have to recognize that a company is a separate corporate personality, and that when wrong is done to a company, then it's the company who has the right of action and is the proper claimant. That's part of the rule in Foss and Harbottle, which has some antiquity. In Prudential and Newman, the rule was further developed in the Court of Appeal that, that one of the reasons that a shareholder couldn't recover the loss of his investment represented by the diminution in the value to his shares was because that was merely a reflection of the loss suffered by the company and did not represent his own personal loss. That was explained by Lord Bingham in Johnson and Gore Wood. And what he said in the House of Lords was, again, that the rights of action belonged to the company. And in those circumstances, it's the company recovering its own loss, which is separate and distinct from any loss suffered by the contributory or the shareholder. Interestingly, that focus on Lord Bingham on the exclusivity of the right of action is somewhat different from the emphasis placed by Lord Millett, who seemed to also consider that the rule which against no reflective loss was also rooted in the principle of there being no double recovery. And it was almost a policy matter also to avoid an unseemly scramble between creditors as they tried to steal a march in relation to the losses otherwise available collectively through the company's own action. There were exceptions, and there's been recognized exceptions to the rule. The famous one is Giles and Rind, where the company cannot bring the claim because the claim is impossible for it to pursue in relation to the remedy, often because, say, the claim is against the liquidator isn't willing to bring the claim. And that sort of exception there's been attempts made to map that out. But the question is, have we really got there? And that's not helped by the fact that in Gardner and Parker, the Court of Appeal tried to extend the principle of no reflective loss, not only to claims brought by the shareholder in his capacity as a shareholder qua investor, but also when he was a creditor or had other rights, for example, arising from his employment. And you will see that Lord Neuberger in that case sought to extend the principle and said that it wasn't merely dependent upon the avoidance of double recovery. Now, that's very much a gallop because I'm conscious of the time and I want to give Seb, who's clearly going to provide his expert analysis, as much time as he can. I'll just end with this, that one academic has called the law as it stood in 2019 in relation to the no reflective loss as some ghastly legal Japanese knotweed. So has that knotweed been pruned? Has it been cut back? Is it any less ghastly? Let's find out, and I'll hand over now to my colleague Seb Oram. Yes, thank you, Seb.
The rule against reflective loss means this. Where a shareholder and the company have concurrent claims against a single defendant, the shareholder can't claim for losses that he has suffered in his capacity as shareholder to the extent that they reflect a diminution in the share value or in distributions in consequence of a loss suffered by the company. In the scope of this talk, I'm going to unpack that rule and specifically to see how the Supreme Court has amended it and refined it in Marex and Sevilleja. I'll set the tune by giving an example of the situations in which the reflective loss rules applies by reference to the facts of the case that started this line of authority, which is the 1982 Court of Appeal decision of Prudential Insurances and Newman. In that case, a meeting of shareholders had been held in order to approve the purchase of assets from another company in which the directors of the company were connected. What was alleged against the directors in a personal claim brought by one of the shareholders is that the directors had fraudulently misrepresented in a circular before that meeting. And the effect of that misrepresentation was to induce the approval of the purchase of the assets. And so the effect of the direct claim was in effect to bring a separate claim by one of the shareholders, the effect of which was to bring into issue a loss suffered by reference of the value of his shareholding. The Supreme Court in Marex considered the scope and the steady creep of the no reflective loss rule, and two issues really arise. One is, what's the scope of the company's claim when you're considering the no reflective loss rule? And secondly, when will an individual shareholder have a separate and distinct loss that allows them to pursue their own claim? The agenda for this talk then, I'm going to cover first of all the decision in Marex, then the rationale for the rule, and then finally move on to the practical implications and the way in which the rule is likely to be applied in the future. I'm focusing on what the law is, not what it should be. So my focus is on the decision of the majority in the Supreme Court. Marex had to decide two issues. The first one was, does the no reflective loss rule apply where the claim that's brought that's conflicting with the company's claim isn't brought by a shareholder, but is brought by a creditor? So that was issue one. Issue two is, if it does apply against the creditor's claim, is there any exception to it? And specifically, is there an exception to the reflective loss rule where the impact of applying the rule would cause injustice because the creditor is unable to recover? In order to see how we get to the Supreme Court, it's worth just seeing how the Court of Appeal had reasoned. It started off its analysis by saying, although the reflective loss principle was once a company law principle, it had now extended beyond that. And its principal role now was one of prevention of double recovery. So on the one hand, the defendant is meeting a claim by the company. On the other hand, it's meeting a claim by the shareholder or potentially the creditor. And that might give rise to a risk of double recovery from the defendant's point of view. The Court of Appeal then took from Lord Millett's analysis in Johnson and Gore Wood, which was the definitive analysis of the scope of the rule, and took a number of propositions from that. The first proposition was the nature of the loss to which the principle applies goes beyond simply the diminution in value of the shares. It's wider than that. The second proposition that the Court of Appeal took was that it's not limited in its application to claims brought by the shareholder in his capacity as shareholder. So pausing there, if the shareholder is also, for example, a director who has a claim under his employment contract, or if the shareholder has another claim as a creditor of the company, those claims are also caught in principle by the reflective loss principle if there is going to be double recovery. And taking those propositions, the Court of Appeal decided that once it's recognized that the justification for the rule is wider, it's difficult to draw a distinction between a claim by a shareholder qua shareholder, by a shareholder qua creditor, and a claim by any other creditor who's not a shareholder. And therefore it decided that it was in principle applicable to any claims by a creditor if that also led to double recovery. That gave rise to some practical problems, specifically in relation to the width of the reflective loss principle and the extent to which it would apply. And if we take the fact of Marex, Marex had obtained judgment against Mr. Sevilleja's companies, and in between the time of draft judgment being delivered and a period of 3 weeks thereafter, it was alleged that Mr. Sevilleja had stripped those companies of assets and moved them into his personal bank accounts. Marex wasn't a shareholder. It was simply a creditor, and it brought a claim under the intentional torts recognised in OBG and Allen to say that what you've done is in effect fraudulent. I have a direct claim against you, Mr. Sevilleja, which corresponds to the value of the judgment that I now can't enforce. So noting there, one, Marex wasn't a creditor, wasn't a shareholder, it was a creditor. And two, the nature of the loss that it was trying to recover, but was prevented, said the Court of Appeal, had nothing to do with the value of the shares. It was the value of a judgment. And it was that sort of practical creep that led to the analysis in Marex and the review of the principle whole scale. What does Marex decide then? Well, these are the key points. First, it decides that there is a no reflective loss principle, but it's more limited in the scope than the Court of Appeal said it was. The principle was established in the Court of Appeal decision in Prudential Industries and Newman, and wouldn't be departed from by the Supreme Court. And the effect of that principle is that it treats a particular kind of loss suffered by a shareholder as being irrecoverable in law. The second point that it decides is that where the rule applies, it has no exceptions. And the third point it decides is that it applies to claims by shareholders in their capacity as shareholders and not to claims by creditors or employees. So it's a far more refined rule than the Court of Appeal thought it was. Marex was decided in the context of an application for service out of the jurisdiction. And so all that was necessary was for Marex to establish that it had the better of the argument as to the existence of a cause of action. Now, in order to have a cause of action, it needed to have a claim for damages. And so the fact that it had this recoverable head of loss meant that permission out of the jurisdiction was properly granted. I now want to focus on what the rationale for the rule was, because that's quite important to establish how it's likely to be applied in the future. In order to do that, I'm going to run through the majority's reasonings and the steps that led to its conclusion. Lord Reed, delivering the principal judgment, reasoned in the following steps. Step one was, generally speaking, and leaving aside the role of companies, if there are two claimants who have concurrent claims against a defendant, so A and B both have claims against C, each of them is generally entitled to pursue their own cause of action as they see fit. The fact that C doesn't have enough money to satisfy both those claims is at risk that A and B take, unless insolvency law applies. But insolvency law is a different set of principles. Lord Reed then said that the no reflective loss rule is a specific rule in company law, and it deals with particular losses suffered by a shareholder. Specifically, it's not based on a principle of avoiding double recovery. It's more limited than that. And what Prudential had decided is that where such a loss exists, it's treated in law as not being one that's recoverable. Lord Reed then went on in step 3 to say that the purpose of treating shareholders differently was aimed at preventing a subversion of the rule in Foss and Harbottle. Now, Foss and Harbottle is a rule that set out the proper claimant rule, and that says that there are two limbs to it. Limb 1 is, if a wrong is suffered by the company, the proper claimant to pursue that claim is the company. A second limb of the rule is that where the alleged wrong is one that can be ratified by a majority decision of the shareholders, it's not competent for one shareholder to force the majority into a decision as to whether or not to pursue that claim. In other words, the decision whether or not to pursue a cause of action is one that has to be decided on a majority basis. And Lord Reed said that the reason that the no reflective loss rule is aimed at preventing that rule from being subverted is that it gives rise to the potential for an individual shareholder to pursue a direct claim which competes with the company's claim. And so what he's envisaging is a defendant is facing a claim by the company. An individual shareholder, as in the case of Prudential and Newman, asserts a direct claim in deceit. And the defendant then has to decide, well, how do I settle off those two claims? And that might prejudice the way in which it would settle the company's claim. In the fourth step in the reasoning, his lordship said that a bright line rule that these losses are irrecoverable are better than leaving the decision whether or not individual losses are recoverable to be decided as part of the trial process. And that was a significant difference between what the majority say in Marex and what the minority said. The minority wouldn't have recognized a rule at all and would simply have said that it's dealt with by case management, certain parts of the law of damages, such as subrogation, and it's dealt with on a fact-specific basis. Let's have a look then at the scope of the rule as it now stands. This is one of the relevant paragraphs in which Lord Reed sets out the principle, and it sets out the components of what the rule requires. In this next slide, we've got the same quotation on the left. I'm setting out what those essential requirements are. One is there must be concurrent claims of the shareholder and the company. The second is there must be a loss of diminution of share value or dividends, which forms the basis or part of the basis of the shareholder's claim. And the third thing is there's no application of the rule other than to claims brought by shareholders in their capacity as shareholders. So those are the three essential requirements that make up the no reflective loss rule. I want to now go on to look at the practical implications of that. If that's what the Supreme Court decided, how's it likely to be applied in the future? And there are a number of permutations that we need to consider. The first is, what happens if the shareholder has a claim, the company has no concurrent claim? Well, it follows in those circumstances from what I've just described, the reflective loss rule doesn't then apply. Examples that were given in the course of the proceedings were a director of a one-man company is run over and sustains a personal injury accident from the defendant. And because he's gaining his income from the one-man company, he's claiming the value of his lost dividends. Now, because the company has no right of action against the person who committed the accident, there's no reason why the director's claim should be diminished if there's no competing claim by the company. In other words, the proper claimant rule has no application, therefore the no reflective loss rule has no application. A similar sort of situation would apply if there's a contract between the shareholder and a third party and no similar contract between the company and the third party. The second situation is where the company does have a claim but doesn't pursue it. And the situation here is that the no reflective loss rule does still apply. Bear in mind, it's no longer based on a risk of double recovery, and that any remedy that the shareholder has to be exerted under company law. So what he might do, for example, is exercise his rights under the articles, convene a meeting to pass a resolution, or apply to the court to bring a derivative action to require the company to bring that claim. So again, this reflects the fact that it is a corollary to the second rule in Foss and Harbottle. In other words, it's the majority of the company who have to decide what happens to the company's claims. The third situation is where the company does have a concurrent claim, but that claim is barred. This is a slightly knotty issue because it's not dealt with in terms in the Supreme Court's decision. What the Supreme Court did do is disapprove of the causation analysis that Lord Millett had said in Gore Wood. So what Lord Millett had said is, let's imagine a situation where company has a claim, but it isn't brought in time, and so a limitation defense is raised. And in those circumstances, Lord Millett says, the reason that the shareholder can't bring his own claim is that the decision to allow the claim to lapse was that of the company, and therefore the rule still applied. And that analysis was doubted because it's seemed rather artificial. A claim by the company might not be pursued for very many reasons, not least, for example, that there might be different dates of knowledge in relation to the limitation claim if Section 14A of the Limitation Act applied. The likely situation at the moment is that because the Supreme Court has said that it's the type of loss that is irrecoverable, in other words, it is legally not a loss that's sustained by the shareholder, and in these circumstances, the shareholder's claim is probably still barred. That isn't the final word on the subject, though, because it does seem to me that it depends on the nature of the defendant's defence. So there might be a difference, for example, if the defence was, or the judgment in court was, there was no contract between the company and the putative defendant, or that the contract was void. In other words, there never was a claim or a cause of action in the first place. Those sorts of reasons for dismissing the concurrent claim might give rise to a different analysis. Another situation we're considering is what would a creditor's claim be brought? Well, it follows from Marex itself that the answer to that is no. We're limited to situations in which the shareholder has a claim. Are there any exceptions to the rule? Well, again, it follows from Marex that they decided there is no exception to the rule where it applies. It is simply a legal reflection on the nature of the loss that's being claimed. The fact that the tort is intentionally inflicted doesn't give rise to any exception. One query that occurred to me is, would it be possible, given that the rule is now based on Foss and Harbottle, to create an exception from the very exceptions that exist in the rule of Foss and Harbottle that used to exist? Under company law, there are a number of reasons why Foss and Harbottle might not apply. Those were, for example, if it related to an illegal or an ultra vires activity, if there had been a fraud on the minority in deciding not to pursue the claim, or resolutions that were improperly passed. And the argument might well be that since those claims don't subvert the proper claimant rule, the no reflective loss rule shouldn't be engaged either. It seems to me that the probable response to that is that they might justify permission for a company action. In other words, it would entitle the minority shareholder to bring a derivative claim, but they can't possibly change the character of the loss that is being claimed. And if it's irrecoverable, because that's what the Supreme Court has decided, then it can't create a claim because there is no cause of action. The only exception might be, although I'm not sure it's really an exception, is that if the shareholder can show that there is a separate and distinct loss that he has suffered over and above the company. That brings us on to separate and distinct losses. This seems to me to be the area in which the law is most likely to develop. And there was a significant difference between what the majority and the minority decided. Everyone was unanimous that the flaw in the way in which the reflective loss principle had been applied was to assume that because the assets of the company are diminished, that will necessarily reflect in a diminution of the share value. And they said that's not realistic, because there might be situations in which a tort is committed and the assets are replenished, but there's still been a knock on the valuation of the company and value of the shares. All their lordships are agreed with that, and they agreed that it's not simply therefore a question of deciding whether or not there's been a diminution of the net assets. What they don't decide, because it wasn't necessary as part of the, in effect, interim application that Marex was bringing, is decide how one applies that. And so it seems to me we still face the same problem of at what point during the proceedings does the court have to siphon out what is a loss suffered by the company and what is a loss that is suffered separately and distinctly by the shareholder over and above that. One other issue that the Marex case decides is, does the no reflective loss rule apply in any other context? One issue that we've been asked about is former members. There was an authority in UCP, PLC and Nectarus, that's a 2019 decision of the Commercial Court, that had said even on the old law, it didn't apply. And that's because a claimant who's no longer a shareholder at the time of his claim can't be bound by a rule that prohibits shareholders from bringing their claim. It seems to me that that decision is now ripe for review, and it seems to me that the likely outcome is probably the opposite. But it might be a question that's fact sensitive about the nature of the loss that's being alleged. This issue was touched on by Lord Sales in paragraph 158 of his decision, and he recognised the fact that there might be a situation in which a shareholder sells his shares at a time where the market knows and prices into the share value, or in other words, the sale price for the shares, that there has been wrongdoing in the company. And in those circumstances, the sale that he effects of his shares would crystallize an actual loss because of the knowledge of that claim. My view is that in those circumstances, there would be a separate and distinct loss, that is a demonstrable change in the value of the shares that he would have acquired by virtue of the wrong to the company. So that's capable of being a separate and distinct loss suffered by the shareholder. But equally, for any other kind of loss, whether or not the shareholder has sold his shares should make no difference. If the kind of loss is irrecoverable in principle, why should it make any difference to that the member has now sold his shares unless he's suffered a separate and distinct loss of the kind that I've just described? The second issue is, does it apply in context outside the company law? It might well apply, for example, in the context of trusts, where, for example, a beneficiary under a trust wanted to assert a claim against an advisor to the trust, which depended on negligence in the performance of duties to the trust. And coming just towards the end, some final points. How does it apply to foreign companies? Well, that issue was raised inconclusively in the Court of Appeal decision in Harding and Whelans in 2005. It was described as a nice question, and it seems to me that the analysis from Marex now demonstrates that the underpinning of this doctrine is an express or an implied agreement under the articles of the company. In other words, when a shareholder invests in a company, he does so on the basis that he's not entitled to pursue certain types of claim. That's an implied understanding. If that's right, it seems to me that's not a question of procedure that's decided on the law of the proceedings, but it's a law of substance to be determined under the law of incorporation. And ordinarily, those sorts of issues, Dicey and Collins says in Rule 175, would be determined by the proper company law that applies to the company. A few concluding comments then. The effect of Marex is that no reflective loss rule has been recast and limited. We need to treat with caution those authorities that were decided before it, and any in particular that relied on Johnson and Gorwood, that had previously explained the rule on the basis of double recovery. It isn't a principle of the law of damages, but one of company law. That leaves the question that always strikes me is, how big of a problem is this in practice? How often does the claim arise against for these sorts of losses of diminution in value against third parties? It seems to me that it's pretty rare. It might arise in the context of certain intentional torts, as in Marex, where there was a deliberate decision to try and attack a judgment by depleting the assets of a company. It might arise in particular specific torts where an assumed responsibility has arisen in respect to the value of the shares. So accountants' advice about investments and so on. In those circumstances, might it have been preferable to deal with it on a scope of duty analysis? In other words, looking at it from the defendant's point of view, are these losses that were ever recoverable? And it's not specifically a company law problem. But in any event, that's not where we are. It is a company law principle. And the analysis now depends on identifying the two claims and seeing if we can identify a separate and distinct loss on behalf of the shareholder. That's a brief canter through the Marex decision. And David, I'll pass back to you.
Thank you very much indeed. If you could stop sharing the screen, that'd be great. Thank you very much indeed, Seb. And thank you, Naomi, once again. And both Naomi and Seb will have unmuted themselves because we're going to spend probably 10 minutes if we can, where we've run over a little bit, but that's understandable given the substance of these subjects that we're discussing today. We've had a lot of questions, and thank you for those questions. So without further ado, I'm going to start fielding some of those questions to our panelists and holding a discussion about them. Before I do that, can I just mention to those of you who've joined us and who're still with us that that both Seb and Naomi belong to our commercial group. This is one of the larger groups of chambers, specialisms, and it's been a very busy year for the commercial group. If you've got any further inquiries concerning the group and the individual members, then by all means get in touch with one of the Chambers directors or clerks, David Fielder or Matt Wildish in London, Mark Heath in Bristol, and James Parks in Birmingham. Will be very pleased to talk to you. So with that in mind, can I just go to some of the questions that we've had in the chat? And we've had quite a lot of questions on vicarious liability, and I am grateful for those questions. So some of these questions I can take together. Naomi, issues have been raised as to people such as an amateur coach working for a football club which carries the insurance, or that's been asked by Julie Chappell, and Andrea has asked about volunteer members of a mountain rescue team. So volunteer members of a volunteer rescue team itself is a non-for-profit, non-commercial organization. And Warren has asked about bouncers who are standing outside clubs. So those are three different characteristics of people who are independent in the sense that they're not within an employment relationship. So can you give us some assistance on those three?
Very, very good questions. In relation to the volunteers, there is some case law about volunteers. There's a recent High Court case, which I can post the reference for in the chat, called DSN and Blackpool Football Club. Bear with me while I do that. I'm going to put it on the chat box so that everybody can see it. And in that case, it was a volunteer football coach and the football club was found to be vicariously liable, although it was a club where finances were constrained and there were employees, and it appears that this particular volunteer was doing very much a job of an employee, but they simply couldn't afford to pay him. So I think there will be circumstances where volunteers are in a relationship akin to employment, but as with all these cases, very much going to depend on the facts of the case. So I think that's as far as I can go on volunteers. In relation to bouncers, I saw the question, and in particular it mentioned the fact they were uninsured. Again, it's going to be a matter of the facts. In both the Barclays Bank decision and the Kafagi decision, it was relevant that the individuals did have their own insurance, and certainly in the employment context, we're looking at whether or not somebody's an independent contractor. Insurance is one of the factors which might demonstrate you're running your own business. That's not necessarily be all and end all. It will depend on the type of business, whether it's expected for people to have their own insurance and that sort of thing. So I think in the bouncer case, again, it's going to depend on some of the other facts, but insurance is one of them.
Thank you. Now, Andrew Wesson has pointed out that in relation to Data Protection Act matters, that there may be obligations that give rise to actions against the employee that are independent from the vicarious liability principle. Do you want to just comment on that? I mean, that sounds to be right.
I need to say you're right, and in fact, another part of the Barclays judgment, sorry, not the Morrison's judgment was about whether or not the Data Protection Act even allowed for vicarious liability and other such questions. So it's not really in the scope of this webinar, but I think he's right that there are other issues there. But in terms of vicarious liability, that was as far as the judgment went.
Okay, but before we move on to non-reflective loss and matters for Seb, can I just say we've had a lot of questions on vicarious liability, and I apologise to those people who've asked questions who've not had their questions answered online, but no doubt this can be followed up. But there's one question from Sushil that I want to, no, it was actually from Neris that I want to just ask, and that is, can there be effectively a disclaimer? Can the employer, or not the employer, but can the person who's the putative defendant, say in respect of an independent contractor, make it clear to all the people who are potential parties that that this person is not part of their business? And if so, how is that best expressed?
Yes, it can be done. That won't stop a court looking at the underlying relationship, and that's both the case in the employment law context and also in the vicarious liability context. A court can go beyond what is either contractually or otherwise written down. But I can imagine that it would be a useful factor in demonstrating that somebody is acting as an independent contractor if there is a clear agreement between the parties that that's the case.
Well, thank you very much indeed. Now turning to Seb, we had some questions on the effect of Marex from a number of people, and I think you've answered Atul's question concerning the applicable law in relation to foreign companies. But Ali Murad asks, does the decision of Marex impact the position of a claim by a former shareholder in diminution? He thinks that the Supreme Court didn't specifically address that point. And does the fact that the creditors' employees are no longer barred by the principle mean that the former shareholders will also not be barred?
I agree that the Supreme Court doesn't decide that. It does seem to me that the way in which they reasoned is that it's the nature of the loss that's irrecoverable. So I think we need to distinguish between two things. Shareholder has a claim, sells his shares, and as a result of that, the value of the share price that he obtains is less than he would have received from the purchaser, but for the wrong. That's capable of being a separate and distinct wrong, a separate and distinct loss that isn't suffered by the company. Beyond that kind of loss, it seems to me that the fact that the shareholder has left the company shouldn't make any difference. If the purpose of the rule is to not subvert the proper claimant rule, one assumes that any cause of action that the company has would continue in the company's name, and the transferee of the share is entitled to get the benefit of it from the company. So in those circumstances, it seems to me pretty difficult to say that it would make any difference.
Yes.
He's no longer a former shareholder.
Yes, that seems right. And Andrew asks another question. He says, what if the directors of a PLC don't make the necessary declarations to the stock exchange, and that affects the value or the price of the shares, and the shareholders as a result can't sell in time? So is that loss recoverable, and if so, against whom?
It raises a difficult question as to whether or not the directors would be responsible, whether there's a claim between the company and the directors in respect of that sort of loss. So potentially one answer is, if there's no such claim at all, then there's no concurrency between the shareholder's claim and the director's claim, in which case no reflective loss rule doesn't apply at all. If there is such a claim, then it seems to me that in principle that sort of loss might be irrecoverable, because it's certainly a diminution type claim, and in principle it might depend on the nature of the declaration that wasn't made to the stock exchange and what gave rise to it, but in principle it's a sort of loss that seems to be irrecoverable on the basis of what Marex has decided.
Yes, and Roman asks an interesting question. It says, if a majority shareholder were to strip a company of its assets, and in doing so is not only in breach of his fiduciary duty to the company, but is also in breach of a shareholders agreement, is it possible for the shareholder to sue that controlling shareholder for breach of the obligations under the shareholders agreement on the basis that's a separate and distinct loss from the loss suffered by the company?
Well, technically they could sue. I suspect that the loss wouldn't be recoverable other than by the company, so you may result with nothing more than nominal damages. It seems to me the fact that it's a majority shareholder would mean that it would be pretty strong grounds of a court giving permission for the company to bring a claim in a derivative action.
Yes.
Because of the nature of the wrong and the fact that it's a majority shareholder, there can't be a ratification by the company, so the court would almost certainly give permission for the company to bring the claim.
Yes. And I agree with you that Part 19 of the Civil Procedure Rules and the use of derivative actions is sometimes overlooked and neglected as potentially the answer lying within a procedural device, rather than trying to craft new law and new relationship principles. So yes, I think it's worth going back to that, reminding people of that. And then finally, before we break, I don't know whether either of you want to tackle this question. The question is that somebody has a claimant working for a company which is a charity, and they're a director, and their role is to obtain funding for the charity, and they have time off work because of injuries. It sounds like such a specific set of questions that I imagine in somebody's file. But anyhow, as a result, the charity doesn't obtain charitable donations. What claim can they bring, if any? It sounds, I don't know whether either of you want to tackle that.
But it seems to me it depends on the nature of the wrong that the directors suffered. I mean, it's not, from those facts, it's not necessarily to be assumed that there is a cause of action that the director has.
Yeah.
But
and
it
it's a
seems
very
to me,
different question, but I'm not sure it arises either on either of the two subjects we're discussing. But I think Laura has raised an interesting question, which probably is worthy of greater exploration at some stage.
Absolutely. I thought my assumption reading that was something like the fundraiser had been in a car accident, and was there any claim that could be brought? And my immediate reaction to that would be, I think there'd be a remoteness problem there. But it's a very interesting question.
I'd agree with that. I think it would be a
Great.
remoteness
Well, we're just coming up to 20 minutes after the hour, so we've taken up a lot of time. There's still over 200 people online. Thank you for those of you that stayed on. We had at one stage, I think, getting on for 390 people during the talks. I'm very grateful for those of you that have participated. We hope you found it useful. As you know, we've been running programs such as this throughout the lockdown period. We've had fantastic support. And I'd like to thank Lisa Watts, who's online, who's been our invigilator. She's been our guide and our mentor, and has taught us the skills that we've demonstrated today in terms of our presentations. So thank you to Lisa and the rest of the team. Thank you very much indeed, and I'll say goodbye now. It's goodbye from me.
Thank you. Goodbye.
Goodbye.
Bye-bye.